Hello and welcome to Legally Speaking with me, Tarun Nangia. Today we continue our series titled India's Top Litigators. You have earlier seen names like Dr. Abhishek Manu Singhvi in earlier part and senior advocate Mukul Rohatgi, who served as the Attorney General of India on this very show. As we continue our series, we are going to today talk to a law firm which is one of India's top litigation law firms at the Delhi High Court, the Supreme Court, the NCLT, the NCLAT, and other forums. It has a list of corporate clients that are the who's who of India Inc. It is a trusted name as far as high-stake litigation is concerned, and the law firm is headed by Advocate Mahesh Agarwal, and the law firm is Agarwal Law Associates. So today we will discuss his journey, also the kind of work that he's been doing, and what does it take to be involved in litigations that have implications in lakhs of crores, not hundreds or thousands of crores. Good to see you, Mr. Mahesh Agarwal.
Hi, good evening.
And thank you for your time.
Thank you for calling us.
At the outset, given that you're such a big name in the litigation business in India today, if you could tell us a little about yourself for a lot of people who would like to know what it is to be Mahesh Agarwal and who is Mahesh Agarwal.
So, we are a family of lawyers. I'm third generation. My grandfather was a lawyer. My father is a lawyer. And I started off in 1990. And what I did was, I became a lawyer in 93. But I started work in a law firm in Bombay even before I joined the law college. So that 3 years head start of working full time, 10 to 5, during that law college days was the big support which I had. And that's how I got connected with the Bombay professionalism. The way of working in Bombay was quite different from Delhi. So that gave me a huge head start. So when I joined our firm in 1993 in Delhi, I was already 3 years ahead. And that was a time, luckily or unluckily, the Harshad Mehta scam had happened in 1992. So when I started my work in 93, I was kind of representing almost everybody in that scam, right from PNB, Standard Chartered Bank, various banks. Almost all banks were with us, including NHB. So I had that commercial background and semi-criminal background for first 5-7 years of my practice. That gave me a huge boost.
I see whenever I've met you that a very busy person, you're continuously on phone calls. Does law mean being in touch with clients a lot of times, updating them? What is it like to?
So law is a multifaceted thing. It is not just clients, not just law. You have to keep updated with the government policies, what is happening in the business environment, which business groups are doing what are the competitions, inter-business rivalry, inter-corporate rivalry. And in addition to all this, you have to know what's going on in the courts. So all the time you have to be updated with what's going on in current time.
So I want to know from you how large team you have. We saw your wonderful office. It's a pretty large office. And I saw many conference rooms as I walked into this office. I saw people huddled into rooms, strategizing matters. How many people do you have?
So we shifted here a year back. Before that, we had 3 locations in Meghali market.
Okay.
And I was finding it difficult to control from 3 different locations. So we have now centered at one place in Mercantile House in Connaught Place. And we have about 100 lawyers, 100 staff
yes,
and lawyers. So, and all are
and
doing
only
one
litigation.
thing. Yeah, all doing only one thing, which is litigation. We do not have that corporate merger acquisition kind of practice. Basically, going to courts and fighting for our clients.
See, you are at the top in what you do today in the country. You're one of the top law firms. Is there any reason you only focused on litigation?
No, I thought that one should do what you are best at.
Okay.
I've always done only litigation. Somehow I'm not able to gel at all in having participating in negotiations or preparing documents or doing due diligence. That's not my cup of tea. So I have a team which is focused on litigation. We do just that. And the clients come to us because we are specialists in this.
So, that's why you're at the top.
Right.
I want to know from you that you have been involved in some of the biggest litigations of the country, having revenue implication for companies in the lakhs of crores, which is a pretty big number. Of course, I'm not going to ask you what you did in all 30 years. I think we will talk forever. But if you could tell me in the past few years, what are the big matters that you have done which have had big revenue implications commercially?
So we have done a large number of corporate matters and having industry-wise impact in the last 10-12 years, starting from the 2G cancellation licenses. We were defending many companies in that. License did get cancelled. There were huge repercussions, and we were successful in getting acquittal in most of the trials, almost all cases. Acquittal in all cases. I was involved in the coal cases, and thereafter, in the recent past, one of the biggest cases was the Vodafone AGR case,
that
which
again
happened in the
has
Supreme
tens
Court.
of thousands of crore.
So that the lesson that gave me was this, and I advise my clients
Yeah.
that when there is a tax demand or there is a revenue demand, every client demands only one thing, that I need a stay. But one has to do a cost benefit analysis that a stay can be killing in the future. So here in the AGR case, we had succeeded right through. We had succeeded before the TD sat. There was some proceedings in the High Court. In the Supreme Court interim orders, throughout we had succeeded, and there was a stay operating. Suddenly, Supreme Court at the end reversed all orders, and the demand started exceeding 50,000 crores. What happened was that people had not provisioned, they had not calculated the interest or kept that interest in account. Finally, we were able to succeed in one way, that the direction of the Supreme Court to make the payment in 3 months was modified to make it in 10 years. So everybody survived. The companies have survived.
What you're saying, that the company survived because you were successful, that you got a relief, where the payment will now be made in 10 years in installments.
Correct. But my point was, an advice to everybody, that when there is a tax demand, one has to calculate, is a stay on payment really worth it, or one should pay in dispute, pay in a deposit, and then fight.
So does that
because it should not happen that something you may be doing business today, and you may be in a position to pay the tax demand. You do not pay because of stay, and suddenly in 10 years the demand becomes 10 times, and at that stage your business doesn't support the payment.
So at ALA, does Mr. Mahesh Agarwal also strategize for the clients on these kind of matters, where you actually get into the business and advise them that whether they ought to pay in installments? Is this also the expertise?
So finally it's a client's decision, but that's our job. I mean, it's not just going to courts, but in terms of in anything to do with litigation, we strategize right from the time an issue crops up as to whether it is worth going to court. If it is worth going to court, then what is the benefit we can get? What is the objective of the litigation? And how do we achieve that?
So
that's a part of strategy. Absolutely.
So it is nothing to do with just court craft. It is end-to-end solution.
End-to-end solution. You have to handle the dispute and resolve the issue. It is not just solving one case.
It's not just court that
not
you're
just
saying.
Court, yes.
Achha, one thing I want to know, one of the recent cases where we saw that you made a very big appearance in Supreme Court was Delhi Airport Metro Express Limited versus the Delhi Metro Rail Corporation. Could you just tell something about the case and then...
So that was an arbitration award, like everybody knows.
Yes.
Damapel, which is the ADAG company, had succeeded.
Yes.
And all they got was payment for the investment they had done.
Yes.
There was no damages, there was no profit, nothing, just the cost. So we got the award, we won in single judge, DB set aside, Supreme Court we won, review we won. Finally, the curative has taken a different view. Now that will result into its own complications. We have to deal with it.
So the last word is not out.
Last word is not out at all, because there are many solutions. It is like a completely scrambled egg. The court has set aside the award, but now what has to be done is yet to be decided.
So you mean to say the last word on the matter is not out yet?
Not at all. It's far from over.
It's far from over. And see, we'll keep a watch on this matter. Now moving on to another case. There was a PIL regarding fixing of medical services and procedures in India, basically the price monitoring. What was that case about?
So what happened was, these series of cases started in 2020 during COVID. Some petitions were filed that for COVID care, COVID treatment, COVID vaccination, there should be a price fixation. There should be a bar or a top price.
Okay.
So we had contested these cases during COVID at that time. The court was with us, and there was no orders passed in favor of anybody directing the hospitals to fix a ceiling. Now those series of cases have come up again in the Supreme Court, and about 2 months back one of the court passed an order that if the government doesn't come up with a solution to regulate or fix prices, then the court may impose CGHS rates. So we
on private hospitals?
On all private hospitals. So we appeared on behalf of NAT Health, which is an association of all major hospitals, and we put forth before the court that's private enterprise. The government of India is inviting private capital. There's foreign direct investment. high technology is required, investments are required. So there is no question of any price fixation. It's a service industry. So one size fit all cannot work. So that's an ongoing case. Let's see what happens. But as of now, there are no interim orders. So business as usual.
Okay, as of now.
But it is a very critical matter for the healthcare sector at large as to whether there should be any regulation or not.
Because it's an industry-wide impact.
Industry-wise issue. Whether there should be any regulation at all or not. If there should be a regulation, should there be a price fixation? Should there be any ceiling prices? What is the flexibility which the hospitals enjoy? Now, huge foreign direct investment and Indian private investment is riding on the hospitals. Even now, we have not achieved the WHO goal of 3.5 beds per thousand. So, huge investments are required. Any order or any intervention at this stage can stultify the business.
You mean to say this case has implications beyond the current hospitals on the investment climate in India?
Absolutely.
So, were it to go some...
Because it is to start with. Now, if the government wants to fix prices, not just healthcare, but other things also, that will definitely affect foreign direct investment. Why does a person from a foreign country invest in India? For returns.
So what your contention is that private enterprise should have the ability and the freedom to decide the rates in a free market, at what rate it is willing to offer the services.
Everything has to be done on market forces. If anybody overcharges, the patient will not go.
Yes.
So there is a competition, there is a free competition, and there are enough number of hospitals, enough beds, enough doctors to give free competition. Whether it's lawyers, architects, engineers, or CAs, there is no price fixation. Why should it be there in healthcare?
It's a very good point you made. Now we go to an area where your firm has a very large presence. We saw some of the top matters in the National Company Law Tribunal and the National Company Law Appellate Tribunal that you were yourself present in court. I think for the Hinduja matter involving Reliance Capital, you were for the Hinduja group.
Yes.
So, but that is what was in news in the recent months. If you could tell me some other matters in IBC you did, because it's a new law.
Somehow we have been involved in almost every case in IBC right from the beginning, and somehow part of evolution of these cases in the Supreme Court, right from the initial Swiss Revans to Ghanshyam Mishra. Correct? Ghanshyam Mishra was the main judgment which says that the resolution plan is final. Under section 31, all liabilities come to an end. The plan overrides all liabilities, whether it is statutory, private, operational creditors, plan is final. So there is a clean slate policy which was reiterated in Ghanshyam Mishra. So that was, we have been from beginning to end, almost all cases, and from the dirty dozen, for about 9 out of 12 companies, I have been for one or the other, either the resolution applicant.
9 out of 12 companies.
9 out of, either for the resolution applicant or the promoter or somebody or the other.
Now, if you could touch on the regulatory issues that have been covered in IBC, if you could touch on that aspect.
So various issues have been touched and some issues are still pending. The main issue which was touched, as I mentioned to you in Ghanshyam Mishra, was clean slate.
Yes.
That when a company takes over, a new promoter takes over, he has to have a clean slate or a confidence that the old shadows will not come forward.
Can you explain this for it?
So, for example, there is a company which is taken over. There are existing liabilities. Some people make claims during resolution process. Sometimes claims are not made. So, Supreme Court has held whether you have made a claim as an operational creditor or not. If the plan deals with contingent, fixed future liabilities and erases those liabilities, that becomes final. So the liabilities cannot resurrect again and again. That gives confidence to new promoters to take over the company.
One thing that I want to know from you, there are regulatory claims on each company while even it is under IBC. Those regulatory claims also get a haircut price, or those have to be paid in full by the new acquirer?
So our case is that all regulatory dues are also covered by resolution plan. But as we speak, there are one or two issues which are pending in the Supreme Court, mainly two issues, as to whether SEBI demands, which are purely regulatory demands, can they be extinguished under a resolution plan or not? It is an open issue. Second open issue, where there is a conflict within the Ministry of Finance on this part of Enforcement Directorate and the banks, as to whether a company which is acquired, any of its asset, can it be attached for any fault done by the previous promoter? So supposing X acquires a company, X, I won't give names, but X acquires a company, and that company had an old PMLA case because of misdoings or whatever of the old promoter, and the asset is attached. Will ED have a primary charge and that asset will remain attached, or the acquirer will get a clean slate.
Tell
That
me,
issue is yet to be decided.
could you share with the viewers, has there been any court adjudication on this point?
On this point, there has been no adjudication. Supreme Court is yet to take a decision on this. There have been internal discussions within the government as to whether ED demands would survive or not survive. So that's one of the major issues. Another big issue which is happening in the JP resolution, we have a Suraksha, which is a resolution applicant.
Yes.
There was an income tax demand of 33,000 crores.
Okay.
That demand was to be paid over a period of 30 years,
Right.
1,000 crores a year. In the resolution plan, it was provided that the entire income tax demand is quashed. Now the NCLAT has passed an order saying that what is quashed is only the demand which had become operational. So if 3 years installments were due, only that is wiped off and future demands will stay.
Oh,
So a resolution plan can actually fail now. If suddenly you have a demand of 30,000 crore looming on your head, it can't go
nobody
forward.
will acquire.
So the Honorable Supreme Court has agreed to decide it ASAP because the future of over 30,000 home buyers is at stake. So there are certain open ends, certain issues which are still pending, although the Supreme Court has finalized and closed most of the matters.
One thing that your firm has been a part of, which is one of India's most important cases for the mining and the minerals industry, is the MMDR Act case.
No, before that, I tell you on IBC,
Yeah.
another issue
Yes.
which arose was that during the resolution process, if a bidder increases the price or increases the resolution amount, then what happens?
What happens?
There are two cases. We did Ultratech Binani,
Okay.
where Ultratech kind of increased the price.
Revised offer.
And gave a revised offer, and that was accepted.
Was
And that we
accepted?
succeeded, yes. Same thing in Hinduja, which is RCAP. The change mechanism, the challenge mechanism was extended. The prices went up and down. Finally, the Supreme Court has said that where the whole purpose is resolution and maximization of revenue. If the maximization is happening, that should be supported.
Okay. So revised offer can be accepted.
Can be accepted, and this is an issue which is recurring nature. It happens all the time.
Yes.
The bidders keep revising the price.
Yes. So it is healthy
It's a
competition.
healthy competition. Should be there.
Now, the mining industry is one of the biggest industries in India, and your firm had an important role to play in the MMDR Act case. Could you just explain that?
So what happened in MMRT Act? You see, initially, before the coal mine cancellation case, etc., most of the mines were allotted on looking at your profile, looking at your project report. It was free. After the government started the auction process, today all mines, whether it's coal, limestone, iron ore, everything is auctioned.
Everything is optional.
Like 2G, everything is auctioned. So what happened is there were earlier, before 2015, several applications for grant of mining lease which were pending. And the various entrepreneurs have actually set up steel plants or cement plants based on those applications, based on the hope that they will get the lease. So in 2015, MMRD Act provided giving 2 years time for every company to complete the process and get the lease. And if not, the lease would
Even lead
go
would
away.
lapse.
So basically a protection was given to pending cases. The issue now happens, what is the meaning of pending case? That is a live issue pending in the Supreme Court. The competing arguments are as follows. Our case is that I have done everything possible to get the mining lease, right to the sign that the mining lease has to be executed. But for one reason or the other, the state government has not executed the lease. It's not my fault. I have complied with the rules and lease should be granted. The view of the government is the clock is over, 2 years is over, and therefore the application gets over. Lapsed.
So the case is currently pending in Supreme
That is
Court.
pending in this.
Uh,
That will have a huge impact because more than 100 mines.
100 mines.
More than 100 mines all over India are pending
So
adjudication
now
in those
these mines
cases.
are what? From coal to limestone,
kinds.
all kinds,
Everything.
bauxite, everything.
Limestone, bauxite, iron ore, everything.
So this is again a case with
Industry
implications in the
impact.
lakhs of crores over the years.
Absolutely.
So there's another case where income tax, the issue of tax is involved, which is Commissioner of Income Tax versus Blackstone, where your firm has a role to play. Could you explain what that case? Where Blackstone is one of the world's biggest investment companies.
So it's a simple treaty claim like Vodafone. So Blackstone has its office in Singapore. The investment has come from Singapore.
It is a foreign direct
Under the treaty, they get the tax benefit because Singapore is a treaty country. We have succeeded right up to the High Court. Now an issue has been raised that Blackstone investment is actually coming from USA and not Singapore, and therefore treaty benefit will not be there. It's a major issue, not just for Blackstone but for the entire industry. If it is if this concept of look through is accepted, then major tax benefits which have been taken by companies from Mauritius, Singapore will be affected. Today, the law is that if you have a certificate of registration from a particular treaty country, investment has come from that country, the benefit has to be given.
Okay.
But if you start looking at where has the money originated from,
Acha.
where is the management situated,
So is it
those things will
is
have
it
gray
lifting
area.
the corporate veil? Is it?
Something like lifting the corporate veil, which is actually not permissible under the law, under the
Okay.
treaty law.
Okay, that's a very good point you made. There is another case of Edelweiss that you are a part of. Could you explain that case? That was also in the papers.
That's a very unique case where Edelweiss is a clearing member. They have sub-brokers.
Yeah.
One of the sub-brokers here who had many accounts defaulted. There was a complete fraud. As a result of which, Edelweiss was forced to liquidate all the securities given by the broker and pay the NSE clearing exchange. So that has happened. Edelweiss has got no benefit. Entire amount has been paid off. Now some investors have raised an issue that their securities have been in cash even though they were not at fault. Now this issue is alive to be decided in the Honorable Supreme Court as to whether sale by Edelweiss of equities to discharge their debt to NCL where they have not got any benefit, how is this innocent investor going to be compensated?
There's a very important case that you mentioned. I think this will continue to track as it progresses in the Supreme Court. Is it the Supreme Court? Supreme Court. There is this case of Baiju versus Manipal where you had a role to play. They're very famous groups, both of them. Could you share that with us?
So it's a simple case. Baiju, everybody knows, is going under.
Yes.
Now we have a Manipal. Manipal has made a huge investment. And now the challenge is to somehow take control
Or Baiju's.
of Baiju. We have to deal with various banks, institutions who have lent and advanced so monies to Baiju. So there is a huge conflict. And in one of the situations recently, we had to invoke the emergency arbitration clause and invoke SIAC arbitration to get an emergency arbitrator appointed. It was done overnight to get certain reliefs, but that's an ongoing matter just now.
On arbitration, what is your view on arbitration in India?
So arbitration in India, there are two views. Number one, every seminar, every conference, all participants are talking only of alternative dispute resolution. That matters should be referred to arbitration. There should be minimum interference, minimum challenges, hands-off approach. This is what happens in seminars and conferences. But what happens in courts is completely different. Every arbitral award, when it comes to the court, is scrutinized carefully. Every case is like an appeal. The courts are looking at the evidence, the documents, the interpretation. So what is happening is that what we are taught in the book or in the seminar is actually not happening in the court. So I think the mindset has to change. The mindset of accepting what the arbitral tribunal has held, unless it's completely perverse, unacceptable, impossible interpretation, those are different things. But there has to be a hands-off approach. Otherwise, what is the point of spending so much time and money in arbitration? Having this alternate dispute resolution, the whole purpose is to take away the pressure from the court and then go back to court and fight for 10 years.
I think your statement would be music to the ears of the industry because recently we did a show in which some of the top GCs like Vedanta GC, they also said that the arbitral clause was meant to help industry, but we sometimes feel that the aim has not been achieved.
So the stated objective of everybody is hands-off approach, minimize court interference, and court should not look at the arbitral awards. But what is happening is courts are spending as much time as if they were deciding a suit. So what is the point for going for arbitration?
So there's no sense of urgency.
No sense. In fact, so far as I am concerned, I strongly advise the clients not to have an arbitration clause because it only adds a layer of litigation.
One thing is an offhand question. As I'm talking to you, it just came to my mind. We see SLPs in Supreme Court sometimes it's more than 5 years and they've not been adjudicated upon. Do you think for commercial cases involving thousands of crores, implication on jobs, investment, bank loans, you should have special commercial benches in Supreme Court?
No, they should have, but court, last 5-7 years, the courts have made a lot of effort. The Supreme Court has made a lot of effort. Commercial litigation are getting some kind of priority, some attention. Matters which are of the moment are being heard. Now, The problem is that we have so many matters that everything can't be heard. So I think full effort is being made.
Now, one thing,
Nothing to complain there.
you are one of the top law firms in the country who do high-stake commercial litigation, which means whatever decision you take on behalf of the client with his counsel, with his, in a sense, inputs, has a financial implication, running again into thousands of crores, depending on the size of the matter. What is that you bring to the table in terms of strategy for the client? I want to ask you this because, for example, if it is a mining matter, you are looking at maybe 1 lakh files or pages dumped into your office. This is how I see litigation as, even though if it is in an iPad, it will still be 1 lakh files which you have to go through. How do you churn this into what is then finally argued in court? Because you cannot take 1 lakh files to court.
So what is happening now is this over here experience works. Now when we get a case which has gone through 20 years of litigation in trial court and matter has now come to Supreme Court for final adjudication, biggest task is to take out the real point which will have a tipping point or which will turn the case.
And how do you go about finding it?
So that is the time we have to spend for research, deliberation with clients, discussing, looking at case law. It looks very easy, but a lot of time is spent on preparing each and every case. To pick up the right point which will click in the court in that 1 minute is the art we have to develop.
Do you mean to say that when a senior advocate on your behalf and you also yourself go to court, I'm going to come on that,
Yes.
A lot of work is done in the ALA office for those points to be made there? The real strategy, planning, research is done in the office?
See, 9 on 10, 90% of the work is done in the office, right from preparation of the case, creation of legal points, legal research, submissions to argue, precedents, everything is done by us. Of course, counsel has a huge
Role to play.
There's no
denying.
ultimately they are facing the court,
Yes.
and they have to argue and they have to deal with the issues. But there is an equal contribution by us.
I want to know something that you are one of the few, what you can say, managing partners. You yourself land up in court every day and stand for matters. Even if a senior is arguing, you are there in the court. What makes you adopt that strategy of going to court every day?
See, from day one, our policy has been, whether you brief a senior or not, we have to be ready to deal with the case. And I tell all my juniors, colleagues, that we should be ready to argue the case if the senior is not there.
You're prepared.
In fact, today the judges are also forcing lawyers who are appearing to argue whether senior is there or not. So, being a specialist litigation firm, we are able to deal with any eventuality in the court and be ready to present our case. We train, we have internal meetings, internal discussions, internal preparations. So all our lawyers and colleagues are absolutely ready to face the court.
One thing I want to know from you that when you do these kind of matters like the MMDR matter, the AGR matter, which has got policy and revenue implications both. A policy of the government that you have to tweak. See, in the end, when you get them for a payment to be made in say 10 years, there is some tweaking of policy. Do you think that those are the most challenging cases for you? Because in the end, the judge has only that half an hour to listen and you have to distill all this. Do you think that's a big challenge?
So it is a challenge because you have to harmonize many things. You have to harmonize client expectations, the difficulties which may be present in the case, what you can achieve, and how to present before the court. All these things have to be handled. You have to marshal it, think about it, and then present to the client. The client wants a solution. One
thing I want to know from you, you work with some of the most eminent seniors in the country. If you could speak about some of the seniors that you have worked with in the recent times.
So each senior has his own way of working. We have the opportunity to work with almost everybody.
Yes.
Mr. Salve, Mukul Rodgi, Abhishek Singhvi. Everybody you think of, you have worked very closely. Mr. Sibal, Chidambaram, everybody. Each one has a different way of working, different way of presentation, and bring a different thing on the table. So sometimes we have to, looking at the matter, looking of the subject, looking at how it has to be presented, we have to choose the right counsel.
Even that's also very important.
That's a very critical thing, critical part of a lawyer job, to choose the right counsel for the right thing.
Tell me one thing which everybody would like to know. Getting a senior is one point which your law firm is able to get. But to give him the right brief, because you can't give him 30,000 pages, you'll have to give him 20, 40, 50.
Most counsels have no time to go through 10 volumes and 5 volumes. So one has to distill your entire factual narrative and the legal narrative, the presentation, the precedent, so that you have to kind of present, a counsel has to be treated like a judge. You have to present the case before him so that he can present before the judge.
You think that's where your skill comes?
So that's what we are doing.
That's what so today, it's been an interesting discussion. If we went into your client list, we would go from everybody from Birlas to Ambani. Everybody is your client. But today, I really liked this discussion because we were able to go into cases and you explained strategy to us. That is what a lot of people, GCs, promoters want to know, that what strategy, what you bring to the table. One of my parting last questions to you would be, what does the next 5 years at Agarwal Law Associates and Advocate Mahesh Agarwal look at? What do you look, because I'm asking you this because our economy is on the path to become a $6-7 trillion economy. Infrastructure investment is going to be $150 billion. So disputes will increase and legal fees will go 6 times, because this is bound to happen as India's economy grows. What are your plans for AVLA to keep up with that kind of dispute generation? Because disputes are a given when so much of investment will come.
We are fortunate in Delhi to have all major forums here, whether it's Green Tribunal, doing environment matters, Customs Excise, CESTAT.
You do that also?
We do that. Then NCLT, NCLAT, Competition Commission, Supreme Court, High Court. We have varied forums. Now with the complex business environment and the new investments coming in, and the laws are changing so fast, the challenge we have to now face and we have to equip ourselves is to get updated with new laws, new policies, and most of the litigation is actually shifting from like taking money and giving money to regulatory stuff.
Yes.
So we have to train ourselves to understand and deal with regulatory scope, which is whether it's telecom law or it's competition commission law or even NCLT, NCB also part of regulatory.
Yes.
So that is the biggest challenge that I tell all lawyers, to get focused on the new laws which are coming. New forums which are coming, and get equipped to deal with this. Because as we go forward, the litigation is going to be more and more complex. It's not a simple case which one person can deal with. You'll need teams, you'll need associations, you'll need to study a lot and get updated to deal with these issues.
It was a pleasure talking to you. In fact, the takeaways are many from today's interview, and I look forward to the opportunity that next May, which is May 2025, when you would have added, I think, another dozen more clients and done a dozen more big cases, we'll get an opportunity to discuss with you. So here was Advocate Mahesh Agarwal, Managing Partner of Agarwal Law Associates, one of India's top litigation law firms at the City of Delhi, the Supreme Court, Delhi High Court and other forums. He shared his experiences with us. He shared some of the top cases that his firm has strategized, acted for, engaged seniors, successfully argued. And he also shared the complexity of matters in today's India. Best thing he also spoke about is what can be expected in future. We discuss everything from the Insolvency Bankruptcy Court to matters in Supreme Court and other forums. And it has been an indeed interesting talk for me. Hope it was enjoyable for you too. Thank you for joining us today. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.